Good morning, ladies and gentlemen. I think we can start at this point. If anybody is still on the way, you can join us. This is a very important day in our state and in our country. We are attempting something that has actually not been done before in electricity market in Nigeria, and because of its importance, we decided that it should be by way of something that is public, that in that way we can bring transparency to the process, and we can also bring some level of accountability to the process. And so there are two stages to the petition that has been filed. There are two stages to the petition that has been filed. The first stage is the pre-hearing that we're doing today, and then the main hearing that will come subsequently on the 16th of October. I'm sure we have been advised of that date. So for today, we have a short agenda. I guess that most of us have seen the agenda, and we'll make corrections as we go on. If there are any need for corrections, and we will take suggestions at the appropriate time. And so, just to say that you are welcome, I think we should start by knowing who are here. So, if we have another microphone, you can start. So, I have been corrected. The introduction starts from us here and the table. So, my name is Mainpower. I'm the Commissioner for Market Operations, ENUGU State Electricity Commission, and I will be leading us in these proceedings. Engineer Chief Commissioner for Engineering and Safety, member of the panel.
Chidima Uno, General Counsel and Commission Secretary for EERC. Also the Chinelo, the transcriber of the press. Caroline, Director of ENUGU State MODUS House. We are here as observers.
Ositobo, Center Registrar, ENUGU State MODUS House.
Engineer Chukwuchi, Chief Technical Officer, Mainpower Electricity Distribution.
Mercy Obonda, Chief Financial Officer, Mainpower.
Dr. Oluchinelu, Head of Business Intelligence and Process Improvement, Mainpower.
Define Wampo, Head Billing, Mainpower.
Engineer Machuku, Operations EERC.
Emeka is the Head Corporate Communications, Mainpower.
Zoe, Secretary, my guy inclusive electricity operation.
Uchenelu, Chairman, Nigeria Inclusive Electricity Customer Advocacy Intervention.
Akabodi Ikena, Chief Commercial Officer, Mainpower.
Kalauche, Chief Regulatory Officer.
Anthony Atabe, Company Secretary, Legal Advisor, Mainpower.
Dr. Ernest Mukwaya, Managing Director, Mainpower.
Praveen Chaudhary, Group Managing Director, EERC.
Good morning all. Ogubuki Ibaki, General Secretary, Southeast Executive Commerce Association.
Good morning all. Pebuchi Patient Chukwu, Coordinator, ENUGU State, Southeast Electricity Consumers Association.
Thank you. Yes, so once again I say welcome, and we just want to let us understand that the purpose of the pre-hearing is actually to set the gathering for the main hearing, to give a few guidelines and directions on how the hearing will go. And I'd like to say that the hearing will be a quasi-judicial, will have a quasi-judicial nature. And quasi-judicial in the sense that it is something for which a court-like, mimic a bit of court-like setting, for the hearing to take place. And accordingly, a few issues will be handled like in a judicial setting. For example, at the hearing, oath will be administered to people who are making presentations. So if the person that will be speaking for, let's say, Mainpower, he will need to be sworn to an oath, and we understand the reason why we take oaths in proceedings, that truth will be told, and that there are consequences for telling blatant lies, that there is something called perjury. So that is part of the proceeding. And we plan that there are three sets of participation in these proceedings. There will be those who participate as intervenors, and there will be those who participate at observer status, and there are members of the general public who can view the proceedings. Now, for intervenors, they will have the right and opportunity to send their memo. They will also have the opportunity to cross-examine witnesses, and they can ask questions. For those that have observer status, they will not have the right to ask questions or interrogate witnesses, but they will have the power or the privilege to make submission of whatever is of concern to them. The members of the general public will have the opportunity of attendance and witnessing, that they will not be able to ask questions. We want to say this so that it will be orderly. We don't want a situation where somebody will jump from somewhere and say, I have something to say. If you don't fall within these categories, you'll be denied that opportunity. And we're going to time the amount of time that people are going to use, because we don't have the whole year to do this. We have a time frame within which it will be concluded. So we will decide that time at our discretion, please. I hope you don't mind. We will determine that amount of time that people will have to make their presentation. And then there will be a sequence for presentation. Normally, our guidebook or handbook is our business rules. We have a copy here. The Commission Secretary has a copy there. So our business rules is our basic guidebook that we use for these proceedings. And so, as the business rules has provided, the petitioner is the person that has brought about these proceedings. So, is the petitioner that will lead the day, and then subsequently others can make their intervention based on what we receive. There are things we might receive that may not go here or there, but we need to, when we receive them, they will be assessed. Now, I want to also inform us that a link has been provided where materials can be assessed depending on the status of the participants. For interveners, the link will give them access to a lot more materials concerning this proceeding. For those that have observer status, they will have a link that will give them access to the petition, to the order of the commission, and a few other documents of interest. But for people to have that access, both interveners and those that have observer status will sign an NDA, a non-disclosure agreement, which we will pass across in the next few days. So the idea is that nobody gets scandalized. Nobody, these are the days of data protection. So we are mindful of that documents you receive in confidence and are to be accorded the confidentiality they require. So we'll be passing across NDA agreements to all of us at some time, maybe by next week. Anything for it?
Probably want to add that the essence of this is because we are going to have depositions. Those depositions actually will come from interveners, which will be open to everybody who is intervening and the parties concerned. So that, because now what it is, it's more like we are going to work, and then the licensee is not satisfied. Invariably, we are now in public court, because you cannot just go and start doing reviews when actually we have already done the reviews. Now we are even open for people who are concerned, who are involved, to now judge invariably what is done. And then if at the end of the day something comes up, probably which was not considered, then you trigger a review of the order of the commission. I just want to make it clear. But in the process, we also want to make sure that whatever has been given to us is kept confidential. It's only for those who probably want to use it for specific things that they will be allowed access.
Thank you, Engineer. So, like we said, it's a public event, and so there is press coverage, even in this pre-hearing. We are making plans that at the main hearing there will be a lot more publicity about the sitting. And so far, we have received intervention applications from a couple of organizations. If you look at what you have there, the Manufacturing Association of Nigeria has applied and accepted the same thing for EERC, the same thing for the Nigeria Inclusive. I think we abbreviated it to NECI. And then SECA plus the ENUGU State Electrification Agency, EERC. They have applied for participation as interveners, and the ENUGU State Multi-Law Courthouse has been accorded an observer status in the proceeding. So, like Engineer Kabela said, Mainpower, if you look at we have directed at some point that you should submit your petition, and you did that, but you did not submit an accompanying affidavit with the submitted petition. So there was no affidavit affidavit that was filed together with the resubmitted petition. And you know the reason why we asked that you resubmit, because it is rather a strange situation where you are the petitioner and we are the respondent. It cannot be that way. It is a review of what we have done, and not that both of us are litigating. All right. So we ask that you make changes. You make changes in the petition, that you did make consequential changes to the affidavit. So we will request that you file an affidavit that reflects that, and that the affidavit should not be in the nature of a verified affidavit, because what I have here, that affidavit is just about 5 paragraphs. Just about 4 paragraphs, like a verified affidavit. If we want to use this as a witness statement, I don't know whether that will be adequate. So we would like to have a full affidavit of the facts on which parties can ask questions and seek further clarifications. I don't know whether that is clear. Okay. So, like we said, this is a prayer. It's not supposed to be the main event, and it's supposed to be brief. We have actually come to the end of our agenda, and unless we have suggestions, comments from participants.
Okay, I think it will also be necessary, based on what you have in the pre-heaven agenda, we have 3 panel members. So I will constitute 3 commissioners during the hearing. So it's not all the commissioners that are going to participate, because the panel at the end of the day will come up with a decision which the commissioner will now look at and then consider for further necessary actions. So because invariably the commission is being removed from this process, but at the end of the day, they are the ones that will definitely take the final decision. So it's 2 of us that will be participating in the panel. Then, okay, I think that is something critical. I just want us to take note of. That the panel is not the commission. So whatever we do, we now come up with a decision which will also be submitted to all the participated and also the commission. As I said earlier, the idea of this thing is to make sure that whatever is done correctly and the right way. It doesn't necessarily mean the results will come out very good for everybody. Now, I think another thing we also need to remark here is that everybody that has been approved to be an entrepreneur is required to make a deposition. Because when you be speaking, it is on the deposition you're going to make that you will be speaking. That's why you don't necessarily have much time to talk, because whatever you are talking about definitely is supposed to be an open document that everybody definitely will be seeing. But that will give us opportunity of asking questions, because it is a hearing. No decision will be made that day, and then at the end of the day, the interveners also can ask questions based on what actually they've seen that the positions that existed. The deadline for that is going to be 3rd of October. The reason is, once those decisions are made, then we will have ample time, those who are fully engaged, to review whatever is there. Then when you review, if you have questions to ask, you prepare yourself for that day. Then the mandate for the hearing, as Ruben said, is the 16th of October. So, but if you did not do the non-disclosure, we will not be given the link to access the documents that are not available to those who are participating. Just take note of that. Even though you are approved as an intervenor, if you didn't do that, you can't have access to the things you need to have access.
Thank you. So just for the information of the non-lawyer persons here, when we talk about the position, mean statements of oaths in form of affidavits. So there are many ways to go about. I believe that organizations will have legal persons who can guide them on how they set about doing their witness statement or the positions. So please, that is because, like I said, it's a quasi judicial proceeding that we're having, and so people are bound to tell the truth at the risk of perjury. And so please don't perjure yourself if you don't have anything to say. If you have something to say, please bring it on by way of the witness statement. In that way, because I mean, if you need to tell your story, maybe your story is about 1 hour, and we are human beings, we might lose track of what you want to say. But if it's in writing, we already have it, and the hearing you adopt it. And when you adopt it, maybe you have a few minutes to bring further clarification, and then people can ask you questions on that. So that's why we are doing this way. And like the date mentioned is the 3rd of October, but that does not mean it is on the 3rd of October that you must file your paper. You can file your paper as quickly as you sign the NDA and so on, because somehow this part of the world we like to do things on the last day. Please, we are not doing things on the last day.
Then probably finally on my own part, for the interveners, if you have questions, you want to probably get some clarifications, you are very, very free. I also want to emphasize that the discussions we'll be having as regards this program is going to be strictly and purely based on the petition and as it relates to the tariff. It is not time for people to bring complaints of what has not been done or what is not done. It is going to be squarely on the issue at hand, which is Mainpower petitioning a tariff order that EERC had issued to them.
Thank you. So, when I say it's quasi-judicial, I also want to put a caveat, and that caveat is that if you look at our business rules, it says that we're not going to be bound by the strict rules of evidence. So we're not going to be hung up on process and procedures as in a regular court, but we have some elbow room to make sure that things are done as long as they satisfy the requirements of natural justice. That's just the clarification I want to provide. So we ask for comments, suggestions, if there are any. Questions, if there are questions, we can take that at this point. Otherwise, we will bring this debate to an end so that people could face other issues that they have to tackle. So the delays, should I say the delays have it? There's no question. I've been asked to give you a little more time to think about it, and then.
Is there a venue for the final hearing decided?
We will communicate that the venue for the hearing in due course. It might not be here, but it certainly will not be in our office.
Would it be possible for participants to make presentations?
Would it be possible for the participants to make use of presentations during the hearing?
If it should be possible.
Yeah, it's possible, but just like you said, depending on what actually it turns out to, who will set the timeline for whatever you want to do. Yeah, because during your presentation or your intervention, you are free to make presentations if you want to make presentations.
When you said interveners are free to cross-examine witnesses, what do you really mean by that?
So, like, the decision we will make will depend on the arguments and the engagement that Mainpower will be involved in with those who are intervening. Don't forget, the thing we are discussing are things we have worked with you thoroughly, and then you are not satisfied. So it's no longer our beat. While we listen and also ask questions, that will guide what will be the decisions we are going to make at the end of the day for the commission. It's going to be a detailed write-up that we're going to make, where every discussions, every fact presented is detailed. So they are going to have access to the stuff we use in familiar tariff, and in the process, if there are things they probably want to make further inquiries on, they're also allowed to ask questions. But who may decide to limit the questions interveners may ask, maybe 2 or 3 as the case may be. They can't ask more than that because we also want to be mindful of how to manage the time. So there are things that are critical that is going to be discussed. I don't just mention it here, that we will be looking at purely the issue at hand, not anything outside the petition in relation to the tariff order of the commission. Because at the end of the day, it will now may lead to adjustment or amendment of that order. Because the commission, once an order goes out, cannot just go back behind to review tariff and issue under order. The order can only be changed when this exercise has been done to prove the fact that actually, if there are issues that actually were not considered or are not right, it is established, and on that grounds, the needful is done. I don't know if you understand what I'm saying. Okay.
Let me just add that in a normal proceeding, when a witness has said his piece, the opposing side has the right and the power to ask a question. Let's say, for example, a case of dangerous driving, and somebody comes and says, yes, this accident was a result of dangerous driving, this driver drove recklessly and so on. And then the accused or his counsel has the right to ask, where were you at the time when this accident happened that convinced you that it was reckless driving? He can ask you questions that will test the accuracy of what you're saying, to test whether you know what you're saying or whether it is what you heard from somebody. So that is the basis of, yeah, so if an intervener, for example, puts up an argument or puts up a presentation, EEDC, Mainpower, or any other intervener can question, and we, as a regular, can also question somebody based on what they have presented. Yeah.
So who would be the witnesses? That's what was this question. Who could be the witnesses?
We are not looking at witnesses as in maybe an incident had happened, and then what I'm trying to emphasize is this, which is actually the basis for tariff here in Ontario. An exercise has been carried out, and the commission has issued an order. Now the order is supposed to be implemented by somebody. but the person actually is not comfortable with certain things about the order. The person has petitioned. Now, because the business you are doing is not a business that is just normal, it's a huge business, and you have customers that you serve. And those customers you serve actually are the people who pay the bills. Now, they are also going to have an opportunity as a public to also interrogate what has been done. That is the difference. Because if it's a business where maybe you are selling Coca-Cola, you are selling beer, something similar, and there's a natural competition inside it, there's no houses. You can do anything you want to do as far as tariff or pricing is concerned. If you have customers to buy, fine. If you don't have, but this one now is an entity, a business that is regulated. That is the difference. So if we now had fixed what actually we think is right based on numbers we received and it's being contested, then the people who also are involved and experts are also going to be given the opportunity during this hearing to be able to see what is done, evaluate it, and also make their own comments. So it is in the making of that comment that Honorable mentioned that somebody says something that actually is out of place. The parties are involved, those who are intervening, and the commission also have the right to ask questions. When we're asking you questions to be sure of certain things that we will also be reporting on at the end of the day. And one question is also being asked, also guide us to know exactly what is the right thing that will probably guide changes that will have to be done. That is all. So there are no maybe there is going to be a witness who is going to, because this actually what happened between the regulator and the service provider or the regulated.
Thank you, the commissioners. What I wanted to say is that a comment and then a question or clarification. Thank you for the clarification that we can file affidavit, because when the commission directed further that we should do away with the parties, we thought that also with filing of affidavit, but we have gotten that clarity. We're going to do the needful. Then another thing is that I know that this pre-hearing is done pursuant to section 17 of the business rules, and that particular provision talks about experts or working groups. So in the program and the various comments by the commissioners, we didn't hear anything about that. We are wondering, given the nature of the subject matter, what I'm going to ask is that, is the commission also considering having a panel of experts or working group look at the situation so that this thing will be addressed once and for all? Thank you.
No, it doesn't have benefit of people without business. Please, if you're going to be an intervener, I think it's necessary you go through our business rules, because also it's going to guide what and how you'll be doing your stuff. There are various levels, and it's also at the commission's discretion to determine how processes goes. You are free and at liberty to bring in experts to intervene or to support you in your program. If they are approved of, then they will now have the liberty to also stand as an entity defending probably what you have done and so on and so forth. You can also have the experts by your side to also direct you on what you need to do, on the questions you need to ask, and so on and so forth. So we actually set how we want to be done. We also have the liberty to have experts. But it's probably when it will involve maybe let me use the word, I don't know how I'm going to put it. If there's studies or analysis that needed to be done, that is when you can now involve those entities. And when they finish, it is the work that they have produced that is going to be used in whatever that is going to be done. So as it is now, you have every right, every party to get in an expert to join you in this program. They can also get an expert so to stand as interveners, because they also have opportunity of standing on their own to say whatever they want to say, or stay by your side to guide you on what probably they want you to ask, or what they want you to clarify on, and so on and so forth. I don't know if you understand what I'm saying.
Yes, I do, but the group is saying the commission.
Okay, so, Uche, I think, he says that the commission may seek is at the discretion of the commission to do what? For the purpose of establishing the facts of the hearing. The facts are not in doubt. A tariff has been given. Okay, there are issues of dissatisfaction here and there, but the facts are not in doubt. And by the way, even if it's in doubt, the rules give the regulator the discretion when to empanel an expert group and when not to. So in this proceeding, we have not thought it wise or necessary for us to have a separate panel to come and determine the facts for this hearing. But like my colleague said, either of the sides can have an expert to work. Even an intervener can also have a consultant that they can, run some scenarios, with them and see whether it makes sense or it doesn't. All right. So, but for the purpose of this hearing, we are not paneling a working group of experts. Parties have the right to use experts in their own corner.
I think, just like he said, if you see what is written there, the commission may hold a pre-hearing for the purpose of determining the case for hearing. Now, the case for hearing is not something that actually is in doubt. Is it in doubt?
It's not in doubt.
So I'm coming. Then the commission may seek expert opinion and may in this regard compel a working group. Do you see necessary?
The disputations is over the parameter.
Okay, but let's just stay on the fact actually it is still using the word may. It's still our decision as I said earlier on. Okay, fine. There will be a significant for it. Okay.
I don't know whether there are other contributions that we can bring to the table so that we bring this event to close. All right. I think it's been a wonderful opportunity for us to develop the relationships in the NESI and get a better understanding. And I want to thank all of us for honoring this invitation. When the main hearing is planned, you will be given enough notice of the venue and any other consequential directing. Thank you so much, and do have a nice day.
Thank you.